I'd like to introduce today's speaker. Erik Fisk is with a member at the at Whitfield and Eddy Law Firm. Erik has experience in real estate, business, and employment law, business litigation, construction, debtor collector, and family law issues. He is the current chair of the ISBA's real estate section. I will turn it over to Erik.
Thank you, Christy. For this presentation, I've prepared a PowerPoint and we'll focus just on that. What I've done is I've prepared a variety of hypothetical scenarios relative to what I believe are common or somewhat changing ethics issues that present themselves to local counsel and people who work with local counsel. Some of these you'll find will have applicability to a private practitioner like myself, and then some others will have more applicability to a corporate or in-house practitioner. I've found, though, generally that those learning about the ethics requirements particular to corporate counsel are also helpful in the private attorney roles. So that's sort of my method in the approach here. I've got my rules of professional conduct. I assume you have those close at your side as well, and we'll be referring to the relevant rules as it pertains to each situation that comes up. I've got about between 10 and 12 here that we'll go through and try not to get bogged down in the tedium, but at the same time to make sure that we consider these thoroughly and all of their implications. So, in our first slide here, which considers, and we're going to be talking about attorney-client privilege sort of throughout, but let's narrow down into it here, considering that if you consider yourself as an in-house counsel, you close the deals for large corporations. You're either in an in-house transaction department or outside counsel, and you have a situation where a downsizing client raises questions about, I've got it abbreviated there to the AC relationship, but we're talking about really the attorney-client privilege. And then, so who owns it? And I've got a couple different scenarios here. The first one contemplates that the client that you were working for and retained for sells the stock of a subsidiary to another company. So then under that situation, who owns the attorney-client relationship, including the privilege? Would it be your client or the purchasing company? Now the rule here is generally, as the in-house counsel, obviously, or as outside counsel, you represent the institutional client and not any constituent client. However, here in the first scenario where you've got a sale of a stock, the general rule is that the attorney-client relationship and the privilege passes to the successor. So here under A, the client no longer owns the attorney-client relationship and the privilege, which is actually viewed as an asset, but rather the purchasing company does. So that's kind of the general rule in Section A, a full stock sale, which is probably not the most common way of selling corporations. So let's turn down to B, where a client sells substantially all of its assets of a subsidiary to another corporation. And so the decisions here, sort of there was a recognized bright line rule, which was that a privilege never accompanied assets only that were sold to a third party. So the old rule about avoiding the kind of the stock sale situation where you step into the shoes of the seller had traditionally been avoided under asset sales. However, that rule became called into question by a series of cases that, and I'll move forward here, we're talking about the bright line rule, the traditional bright line rule, there's a series of cases that outline what's referred to as the practical consequences rule. Now, under the practical consequences rule, which originally arose in the bankruptcy setting, the courts rejected the bright line approach and explained that because if there's a transaction where the practical consequences of an asset purchase is to transfer virtually all control and continuation of the company's business to a new owner, that the new owner would take control of the right to waive or assert the privilege. And so here, if you've got a dispute that arises after a transaction, there are a variety of arguments that would permit the successor entity in an asset purchase only to retain the privilege, retain the relationship, which most importantly means the right to retain the protection of attorney-client privilege. And now I've identified here that in the Eighth Circuit, there's an Eastern District of Missouri case that applied this standard. It appears to be favorably. It would appear that given the general trend of the law, that this standard is, even in our circuit, the one that will be followed. And so the question arises in the third instance as to if you're contemplating this result, you're contemplating an asset sale. The question is whether there are ways to draft around it in transactional documents. And because I've already revealed my answer slide, of course, you can see that the answer is maybe. Some decisions appear to recognize some ways out of it. One creative way is when lawyers find a way to make a joint representation, where as long as there isn't a dispute between that successor entity and the parent entity, that the privilege would be retained both as to the parent and the sub. The old way was to try to circumscribe the asset sale. More recent decisions have tried to write out privilege, which relates, which will result in sometimes fractures on privilege to pre-transaction and post-transaction. But ultimately, a review of the cases just provides that there's not really any certainty, because a parent who arranged for the relinquishment of the privilege, that is, retained control, would be vulnerable to any further argument that somehow the sub was compelled to operate pursuant to the parent's direction and couldn't be bound by the assertion. So the cases, and there's a number of them in some Delaware cases, that suggest that these drafting techniques will not be honored. So the answer there to that one is a firm maybe. So let's turn to adverse representation. And as private practitioners, this is probably one that plagues us most frequently, where you get conflicts that aren't necessarily sort of by the rule conflicts, but rather raise related tertiary ancillary conflicts. So in this hypothetical, let's assume a private practitioner has a law firm, runs a conflict check, and that conflict search does not reveal any problems with a new defendant in a suit that you wish to bring as his private practitioner. However, one of your partners mentions that she does labor work for the defendant's sister corporation. That is, not the defendant itself, but the sister corp. Your law firm does not represent the parent / other sister corp. They're in different businesses, but they both rely on the parent's law department for legal advice. And so the first question, obviously, is, is there the conflict and the traditional route, of course, is to review the rule that relates to conflicts 1.7. And related to 1.7, it's also worth noting that our professional rules in section 1.13 describe when an organization is a client, the rules at least do not provide a per se type application that affiliate, related, sister, parent entities are included. In fact, 1.13a says that a lawyer employed represents the organization acting through its duly authorized constituents, that is, shareholders, and so on. The ABA did some things to amend the rule, which under the old standard would tend to disfavor an attorney's ability to be adverse to an affiliate corporation, but the ABA amendments to 1.13 made clear that the lawyer was not barred. And then the ABA has also issued an opinion back in 95 that rejected this per se rule. The restatement has taken the same approach. However, and if you look, so in light of this restatement, the ABA opinion, the amendments to 1.13, it would suggest that the lawyer here can represent the client in the suit against the corporate defendant, even without its consent. But what the courts have done is they take a fact-heavy analysis in this approach, and they analyze the way that the corporations are related to each other. In this hypothetical, you see both rely on the parents, sorry about the train whistle, both rely on the parents' law department for legal advice. And so if that said legal advice, management, and the parent was just kind of the service corp and the subsidiaries were shells, the case law would seem to suggest that those would be operationally integrated, which appears to be kind of the developing language on this issue in cases that have been decided in the various circuits approaching this. For example, and this will happen a lot when lawyers change firms and move from representing one client to be adverse to an affiliate. For example, one court in the 10th Circuit on appeal held that ultimately there was a, quote, operationally integrated, closed quote, structure between these two entities. Therefore, the affiliate entity was found to be the client entity, and therefore there was a conflict that was an irreconcilable conflict that prevented representation. The suggestion under these cases is that the prudent attorney is going to clearly define the relationship, who is the client, who is not the client. Obviously, there are the political considerations and the positional conflict issues, but those are beyond the scope of this. At least under the plain text of the rule, the suggestion of this is that the answer would be yes, you could represent the client, but obviously some more inquiry on the related operations between the two entities would be warranted before you are potentially on the business end of a motion to disqualify or worse. And so now we move to kind of what governs a lot of these hypotheticals broadly, and that is identifying the client. So when you have a corporation walks through the door, for example, traditional law firm situation, the question is, who is the client? However, when you're in-house, the client may be or appear to be a constantly shifting concept, and one at least that it's easy to fall into the lulls of business every day and forget the way that certain individuals' interests can tend to cut against what is your client. So under this hypothetical, imagine that you, dear attendee, are a general counsel for a publicly traded client that is a large corporation, you're called by a director on an audit committee. This audit committee, the director overseeing this audit committee has asked you to hire an outside law firm to conduct an internal corporate investigation into accounting irregularities. Now, obviously, here, once we've got a request to hire an outside law firm, it's pretty clear that this director knows that we're getting into a situation that means business, because it's not an inside job. But then, so you hear this, you know at least from your experience that this is not something the general counsel's office should do, but rather that an outside firm do it so that privilege for the company can be retained. The investigating agency / law firm / contractor can be perceived as independent, objective, and their findings would be more reliable in the eyes of a third party. And so you call this outside person, and the outside person on the phone with you immediately asks, well, who is my client? And so that's the question. You've been called by a director who's on a committee. And so the first question is the director your client? So again, we've got sort of the rule approach. And so the defining rule under this circumstance is Rule 1.13a. And as I mentioned before, it's pretty straightforward. It's got a lot of subsections, but subsection A says a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. So the director is obviously a member of the board. The board is the ultimate decision-making kind of controlling entity. But here, under the default position and under the default standard, the director obviously wouldn't be the client for your situation here. Now, second, we turn to the audit committee. Now, the audit committee, remember, they are reviewing some accounting irregularities. So it's a regular, routine, corporate operation of business. That is, you can review your own internal records. So there's nothing untoward about that. They've identified what they believe may be some irregularities that warrant further investigation. However, the audit committee is acting in and through the corporation, so there's no reason to believe that the audit committee's interest diverges from the corporate standard. And if you look at the rule 1.13, it begins to identify circumstances under which, let's say, for example, if we were to consider the director as client, that you may want to consider. For example, subsection B says if a lawyer for an organization knows that an officer, employee, or other person, etc., is engaged in an action, intends to act, or refuses to act in a manner that is a violation of a legal obligation to the organization, the lawyer has to proceed in a manner that's legally necessary to preserve the corporation's interests. And so here we could say, if this director was acting adverse, if the director had suggested that he or she was involved in these irregularities or was somehow trying to cover them up, the lawyer would know at that point that the interest between that director and the corporation had become divergent and would obviously, under 1.13b, which the later part of the rule requires, have to report it up the chain of command. Now, subsection C in the rule, 1.13, indicates that the lawyer has to continue to escalate even if the highest authority fails to address it. And the rest of the rule deals with circumstances where the lawyer is discharged improperly, where the lawyer is investigating a violation of law, and then subsection F, which deals with times where the lawyer is dealing with the organization's directors, officers, etc. And we'll touch on this one later, but there we've got kind of an upjohn standard where we would brief the individual on. And obviously, the lawyer is prevented from representing anyone whose interests are directly adverse to the corporation under Rule 1.7. So here we've got the board of directors. Now, the board of directors kind of falls within the default rule, which is that the corporation, the lawyer who represents the corporation through its board of directors. And so here, this is likely the most correct answer, along with the next answer, the corporation, because the lawyer is representing the corporation through its board, because that's how the corporation acts. The corporation shareholders, obviously incorrect, because the shareholders have certain voting rights, but they don't have the rights to control the corporation. Obviously, if there's derivative litigation and so on, that complicates this as well, but however, they're not the correct answer under this scenario. Now, an interesting side note to this identifying the client issue. And so the hypothetical, and I'm switching back and forth between the slides here, the hypothetical assumes sort of what I'll call a routine circumstance where someone in the normal course of the corporation's business identifies something going on that may be prejudicial or against the corporation's interests. However, we could imagine scenarios where identifying the client might become more problematic. The traditional, most common example that comes up is when you've got a bankruptcy trustee who is taking over assets of a client that's filed for protection under the United States Bankruptcy Code. And so there are frequently disputes about whether the bankruptcy trustee can get access to files that were previously files of the corporation, but where it involved the actions of management who were desperately trying to avoid what would ultimately be the company's downfall. And what this litigation shows us is that desperate times often require desperate measures, and that people do things they otherwise wouldn't normally do. And so the question that for the prudent practitioner is, okay, I've got a situation where identifying the client, that is, whether it's the board, whether it's potentially an executive or a cadre of executives who may be representing the corporation's real interest while there may be someone running amok or a rogue interest. Now, there is a case, and I thought it was an instructive case, by a well-known law firm that came into representing a company that was ultimately going to go into bankruptcy. And here, what this law firm did, Skadden Arps, is in their engagement letter, they identified the client. They said, and as it's reflected here on the slide, we are pleased that you as outside directors, the quote, outside directors of Just for Feet, Inc., that was the company in this circumstance, have decided to engage Skadden to assist you in your review of various matters relative to the company, and then the elliptical for the unnecessary lawyer chatter. The rest of the engagement letter goes on to say, with respect to the company and its subsidiaries and parties affiliated with the outside directors generally, it is our understanding that the Skadden law firm is not being asked to provide and will not be providing legal advice to or establishing an attorney-client relationship with the company, its subsidiaries, any such affiliated party, or any outside director in his individual capacity, and will not be expected to do so unless the Skadden law firm has been asked and has specifically agreed to do so. Now, this engagement letter is interesting because this involved a dispute, as you can tell, in Alabama. And so in 2006, the Alabama Supreme Court held that a bankrupt company's, and that just for feet here, a bankrupt company's trustee could not gain access to the documents created by Skadden because that law firm represented just the company's outside directors and not the company itself. And it is a very fine distinction, but one worth noting in this circumstance, in the event that you are faced with an issue such as this, where a company may be, by virtue of a transaction, by virtue of an impending bankruptcy filing, be put in a situation where other parties could come into privileged or potentially come into privileged information. And so obviously, I think the reminder here in line along with this prudent advice to identify the client and the representation, particularly when things may go poorly, is to remember who your client is, particularly if you're an in-house counsel, on a day-to-day basis. And so then what this does is it preserves what ultimately, I mean, these hypotheticals are sort of interesting, maybe less so here at the end of the year while the ground is covered with snow and it's 0 degrees outside, but are interesting intellectually. But the more important point is the way that they inform how our clients can be harmed and how the special abilities that we have as attorneys to generate attorney-client privilege and protection for documents can be defeated if we are not careful. And so the approach here is to be prudent day to day, assure that privilege protection attaches where appropriate, and that waiver is avoided at all costs. And obviously we've got, if we mess this up, we've got bigger issues, but the most immediate issue is the harm to our clients. And so now, turning away from defining the client to joint representation. And so let's consider this hypothetical that I've got on the screen in front of you, where last year a large corporate client that you're general counsel for spun off a subsidiary to become an independent company. And so then the unexpected happens. The subsidiary that was spun off declares bankruptcy. The bankruptcy trustee, a fine person in social circles, however, calls and demands your law firm's files from the transaction, claiming that during the spinoff you jointly represented the parent and the subsidiary in the spin. So, assuming that you had jointly represented the parent and the subsidiary in the spin, would the bankruptcy trustee have the right to your law firm's file? And what the cases show, where when we've got these corporate family sorts of transactions, the same lawyers are often representing both entities in the transaction. Lawyers represent the entire family in these transactions. They can include not only the in-house lawyers, but also the outside lawyers. And so this scenario, the answer is that yes, the bankruptcy trustee probably can get the records, and it shows the well-recognized principle that jointly represented clients are going to have an equal claim on their joint lawyer files. So this newly independent company can generally access the files generated by the law firm or the in-house legal department that represents both members of the corporate family while they're still members of that family. Thus, the bankruptcy trustee, and in most of these, in a lot of these cases, it is a bankruptcy trustee who's coming in and claiming on behalf of the company right to these files, often to see if and what people can bring claims about. So this bankruptcy trustee will frequently call in to the law firms, law departments to get all communications between lawyers, parent companies, and outside lawyers who represent them in the transaction. And there are scores of examples. Even Troutman Sanders, a large law firm in Texas, committed this wrong when the Southern company it represented spun off a sub known as Mirant when it declared bankruptcy. They tried to claim that because the parties were jointly represented, that they both had the equal right to preserve it, but the court countered that, well, in the event that they're jointly represented, one can invoke the privilege against the other between them in a litigation or dispute between them, which is ultimately what the issue raised. Some commentators would suggest that the client, the subclient, can prospectively waive the conflict so that the lawyer could continue to represent one of the parties after that conflict. And while this is certainly forward-looking, I don't know how it helps the client, but it certainly helps the legal department for the corporation that remains on. And obviously, just what here we need to remember is that when we have joint clients and when they become adversaries, the law is going to allow either of those joint clients access to their common law firm files, and it's going to allow each of them to use them freely in litigation with the other client. So the answer to this hypothetical is probably yes. So now we turn to everyone's favorite rule, and I actually learned a new application of it this year, non-compete agreements involving lawyers. So let's imagine that you are a successful lawyer with a company with a flourishing in-house legal department. You receive an offer from an even better legal department with better benefits, better pay, better company car, telecommuting hours, and so on, whatever goes as good benefits these days. This new company, aptly named Newco, sends you a proposed employment agreement that prevents you from serving in-house for any competition of Newco 1 year after you leave Newco, and then also that precludes your representation adverse to Newco for 5 years after you leave the company. And so the question is, may you sign where you agree not to serve in a competitor's law department for 1 year? And the second question is, can you sign where you agree not to take any representation for 5 years? Now, the non-competition agreement here, the general rule, and those of you who are in-house may be generally aware that non-competes are typically not enforceable. Now, after there had been some consternation some years ago, the ABA came out with a rule that we've adopted in Iowa, and it's Rule 32.5.6. And so obviously our professional rules are preceded by 32 for the Chapter 32. But the rule itself says a lawyer shall not participating in offering or making a partnership, shareholders, operating employment, or other similar type of agreement that restricts the right of a lawyer to practice after termination of a relationship, except an agreement concerning benefits on retirement. So the concept here where you agree the prevention from practice is not going to be permitted, and I've got the citation to the rule there at the bottom of this slide, 32.5.6, whoops. But there's an interesting side note to this as well. If you look at the rule, 5.6, as I'm sure you got right there next to you, there's a related component of this rule which says under subsection B that a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. And so this is a rule with which I recently became acquainted, because a settlement was proposed that I was part of that barred a lawyer's right to practice, and not just broadly to practice law, but rather just to practice and to limit representation of that lawyer, so that the lawyer could not represent one client. And if you look at the rule, it's clear that the rule and its comments would prohibit the lawyer, and the subparagraph B was designed to prevent those settlement agreements that attempted to block, for example, a plaintiff's attorney from practicing either on behalf of that plaintiff or other plaintiffs against the defendant, and the rules specifically bar it. However, there's an exception for the sale of a law practice. And the concept here that the rule preserves is the professional autonomy of the lawyer. And so the first comment tees that up when it says an agreement restricting the rights of lawyers to practice after leaving a firm not only limits their professional autonomy, but also limits the freedom of clients to choose a lawyer. And so there are really two things here: the professional judgment of the lawyer, and then the public's right to be able to choose whatever lawyer they may want to choose. And so these non-competes, at least as they relate to legal practice, are not going to be enforceable. Now, however, the the trailing concept of that is that some courts have found and will enforce certain prohibitions that relate only to the business side, that don't relate to the legal side. For example, a lot of times in the employment world, and people who have highly confident situations, such as an attorney, such as, let's say, an engineer, or someone who's in product development or design or product launch, they would have access to confidential and proprietary information. And so in those circumstances, the ABA itself and a handful of states, they've recognized that companies can ask lawyers to sign agreements that obligate them to preserve confidentiality of information that the in-house lawyers learned. And so, and there are ethics opinions and from both the ABA and states that have been both A, recognized, and B, approved. One such example, in Arizona, ethics opinion upheld a termination agreement between a corporation and an in-house lawyer where there were strict confidentiality agreements. And the ethics board there in Arizona said that the confidentiality restriction was consonant or consistent with the lawyer's already existing obligation to retain client confidences. And it was designed to give the corporation remedies, that is, contractual remedies, in the event that the lawyer ultimately breached. However, obviously, to the extent that they prohibit our ethical right to an obligation to be able to practice law freely, they will be disfavored, not enforced, and or unenforceable. So you can rest easy on that end should you have such a non-compete. And so here's one that frequently comes up: serving on a board of directors. So let's imagine that you have a client or an affiliate client when you're in-house, or if you are a private practice attorney and a client asks you to be on their board of directors. And so you think to yourself, well, first of all, am I allowed to do this? And the answer is yes, you can do it. It's not prevented by the rules. And the special considerations that you should keep in mind, however, and these are identified in the rule about having the institution as a client. Where you need to be aware that serving on the board puts you in, as a lawyer, it puts you in a place where both A, people are going to assume that they can rely on you for legal guidance, but more importantly, B, where your obligation to preserve confidence is to your existing client, and your obligations to another client may threaten privileged confidential communications among and on that board of directors. And so the important thing here to note with the client whose board you're going to serve on is that the confidentiality, the attorney-client privilege, and related strategic type confidential required discussions could be compromised by your participation there if you have duties to another party who potentially is adverse or distinct from that party. And here, the rule relative to conflicts is, and that's the obligation 1.7, conflict of interest in current clients, particularly column or comment 35, which permits a lawyer to serve as a member on the board of directors. However, the lawyer needs to remember that the lawyer may be called on in the event that it's a related, sufficiently related, or the actual entity that you're serving as a client. The lawyer may be called upon, and we need to remember this, to advise the corporation in matters that involve actions of these directors. That is, these other directors on the board you're serving on. And so the lawyer should give consideration to the frequency with which any of these situations may arise, the potential intensity of any such conflict, the effect of the lawyer's resignation from the board, if that would be necessary, and the possibility of the corporation's obtaining legal advice from another lawyer in those situations. That is, will it be simple or difficult? Will the lawyer's participation in and membership in the department impede the progress of a new lawyer who needed to be brought up to snuff? And then the comment continues, if there's a material risk that the dual role will compromise the lawyer's independence of professional judgment, the lawyer should not serve as a director or should cease to act as the corporation's lawyer when a conflict arises. So one or the other needs to be ended. The lawyer should advise the other members of the board as well that in some circumstances, matters discussed at board meetings while that lawyer is present in the capacity of director may not be protected by the attorney-client privilege, and that conflict of interest considerations might require the lawyer's recusal as a director under certain matters of voting, or the lawyer's firm would have to decline representations of the corporations in a matter where there was a conflict. This used to be much more common. It's been declining somewhat more now, but the rules have remained relatively stable in this area. So the caveat there is just to remember the obligations to the client that must be retained when you are serving on that board. So we'll consider another example here. We've got a situation where you serve, you are the general counsel of a 500 shareholder company. And so the 500 is really relevant only as it pertains to the number of shareholders here in the following line. 50 of those shareholders file a derivative suit that targets certain executives who were believed to have engaged in wrongdoing. Now, as soon as this derivative suit is filed, after the demand's been made, plaintiff's lawyers contact you and they identify, or they tell you that they'll be seeking access to your communications with your corporate client's upper management as a part of their expedited discovery. And so the question posed by this hypothetical is, will they get access to these communications? So we've got, 10% of the shareholders, and you're the general counsel, so you're the one dealing with these people individually day by day, and they're the executives, the inline sort of management here. Now, if we turn to the court's analysis when these cases have been brought in litigation, the default position under these rules, and we talked about it in talking about Rule 1.13, we talked about it in the evolving standards of subsidiaries and asset purchase agreement type sales. But the rule remains that the default position is that the corporation's lawyer represents the institution. That is the corp itself, not the constituents, not the employees. So here we've got kind of a wrinkle of, well, if the shareholders own the corporation, should they be seen as the ultimate client? So here, at first blush, the answer would seem most clearly to be no. So like one shareholder out of, let's say, 1 million wouldn't be entitled to gain access to highly confidential information. However, here, if you've got a substantial number of shareholders, in limited circumstances, it may be proper to consider the shareholders as the real client. And so here, I know in an earlier hypothetical, I talked about the shareholders being the ultimate constituents. General rule, no. Here, however, you may have a situation where there's a fiduciary exception, and that's what it's referred to in the law, the fiduciary exception, Courts considering this circumstance have stated that in a somewhat unusual context of the shareholder derivative lawsuit, when we've got a situation where the corporation's shareholders may be seen as the corporation's lawyers' clients, that's where it would be, is in the derivative lawsuit. And so shareholders bringing a claim on behalf of the corp against a third party, for example, is frequently done. And when they allege, for example, that the management failed to fight off the claim or failed to diligently prosecute or diligently defend, starting all the way back as far as 1971, one court recognized that there's a narrow context where shareholders can be seen as the true client. And the courts have considered a variety of factors. The number of shareholders, obviously the key giveaway in this hypothetical. The percentage of stock they own. Here we've got 10% of the shareholders involved in this one. Their bona fide claim, the nature of their claim, the necessity and desirability of them receiving the information, the availability of the information from other sources, whether there's alleged criminal or other illegal or doubtfully legal wrongdoing, whether the wrongdoing relates to past actions where it's more favored than it is if it's prospective, the extent to which the information request is just a fishing expedition, and the like. And this standard has evolved and been referred to as the Garner standard, which is the case it was taken from. And this is obviously an exception to the United States Supreme Court rule in Upjohn, which is that this kind of central control group are the ones who have access to that kind of information. But it's something, at least in the derivative concept, you may think you won't run into it, but I myself have run into it times when I didn't expect that would be the case. And so we come to our final. I was thinking of either closing on, I think this is the final, yep, closing on knock knock, it's the FBI, or closing on Merry Christmas, you're fired, with the non-compete one. And so I figured that we close with the FBI because it's just a little more foreboding. We're all going into the new year and just get a little bit of anxiety under our skin, imagining that the FBI comes to knock on your door. And so let's imagine you have a scenario where you worked with outside counsel. That is, your inside counsel. You had outside counsel brought in during an investigation of 3 executives' possible wrongdoing, okay? And so obviously we've got the kind of situation where, you know, we've got the traditional example of when do we bring outside counsel in? Well, we need outside counsel to be objective. We want to preserve attorney-client privilege. We don't want to become witnesses against, that is, our internal legal department don't want to become witnesses in the event these executives have been found to do something wrong, so that we're disqualified from representing our client. And so we bring in outside counsel. And so let's assume that you're working with outside counsel. They're doing the investigation. And we've got, you know, the example where the employee comes in, and it's the employee who you already know has a potentially adverse interest against your client. It's not been proved yet, but it's potentially adverse. And so we've got, what happens if you say these following statements? And these statements are kind of referred to as, in the literature, as kind of the quote, Upjohn warning. That is, I represent Corp. I don't represent you. I can answer your questions, but I can't give you legal advice. And so let's say you approach it a few different ways. In the first circumstance, you say, we represent the company, but we could represent you as well as long as no conflict appeared. And so there seems to fall kind of within what Upjohn says. And then in the second one, we can represent you until such time as there appears to be a conflict of interest. Obviously, you can see we start to kind of watering this down. And so let's assume you've given each of these kind of warnings. So the investigation continues. After the wrongdoing is discovered, your executives are fired. Obviously, the federal government finds out, sees the press story, investigates, and they want your interview notes. You're a very detailed note taker, and they want to ask explicitly for your interviews. And you look back at your interviews and you see that these are the statements that you made. Or, you know, in either scenario, as an alternative, you made one of these statements. And so obviously the government says, hey, we want your notes. Your thought, hey, I am lawyer for institution. You don't get my notes. They're work product. They're privileged. No. The former employees say, well, you jointly represented us and we can't waive, we get to veto your waiver. And the feds counter your argument with, well, it's a crime, and so we get them. And so can you waive the privilege covering your interview of these then employees? So the danger here, obviously, that we're kind of dancing around is that you don't want to get into a situation where, when you're dealing with corporate executives in these circumstances where you have potential wrongdoing, you do not want to be where you are perceived as or considering or conducting a joint representation. So in your standard Upjohn warning, obviously you explain the identity of the client when you know or reasonably know that your organization's interests are adverse to those of the constituents. And so if we look back at these two statements, we represent the company, but we could represent you as well as long as no conflict appeared. Again, that suggests that we could represent you, but it at least still is that we represent the company. The second one is a little less clear, and there have been decisions where courts have seen where they found what have been called either watered down Upjohn warnings or otherwise. One such example, and you know, they're in other big litigation jurisdictions like the Southern District of New York. They've criticized these watered up down warnings that are given to executives they're interviewing, obviously because the lawyer will make statements like, I represent company, but I could represent you as well. Or I represent you until such time as there appears to be a conflict, which was even more heavily criticized, that second one there, and may accidentally get you in a situation where you've unintentionally created a joint representation. So the best answer to this hypothetical is maybe, depending on how strict reviewing judge is onto the watering down of that Upjohn instruction. And so now we have come to minute 56 of the presentation. I was informed by Ms. Cronin to allow a few minutes for questions in the event you have any.